Hi, I'm Edward Francis, one of the senior partners at Aust Migration and Settlement Services. I have been in the industry for over 20 years as a registered migration consultant. This video is about RRV refusals. Please contact us at info@austmss.com.au or give us a call to ask any questions. Very important. Please like, subscribe, and turn on the notification bell to remain updated on new migration videos. RRV refusals. If you apply for a resident return visa onshore and receive a refusal, you will be able to have the decision reviewed by Administrative Appeals Tribunal. Applications made offshore do not usually come with the review rights. However, if you have a close family member living in Australia as a citizen or a permanent resident, they may be able to request review of the decision. Many people ask us, what happens when a permanent residency travel facility ends? If you do not leave Australia, you can continue living here indefinitely with permanent residency status. If you want to travel outside of Australia and re-enter once your travel facility has entered, you will need to apply for another resident return visa. We advise doing this before you leave the country, although you can apply offshore if necessary. Subclass 155 resident return visa. Australian permanent residence, it allows the visa holder to travel in Australia indefinitely and to travel to Australia from overseas for up to a period of 5 years from the date the visa was granted. If a permanent resident holder is overseas outside of the 5-year period, a subclass 155 resident return visa is required if they wish to return to Australia. The resident return visa allows permanent resident of Australia to return to Australia after traveling overseas. Resident return visa applicants must be an Australian permanent resident, a former Australian permanent resident whose last permanent visa was not cancelled, or a former Australian citizen who lost or renounced their citizenship. Offshore applicants who have been outside Australia for more than 5 continuous years since their last permanent residency was granted must demonstrate compelling reasons for their absence. Here we are going to discuss a case study. Our client was a former Australian permanent resident who departed Australia more than 15 years when she was very young. Now she is in Australia as a holder of temporary visa. Our role at this point of time, we conducted a thorough assessment and review of our client's history before determining subclass 155 resident return visa was the most suitable option. The outcome of this case is the case officer was satisfied that our client demonstrated substantial ties were a benefit to Australia and that compelling reasons for her absence was present in the case. Subclass 155 was approved. Case study number 2. A former Australian permanent resident family who departed Australia more than 15 years ago sent their child to Australia on a student visa to study here. Our role was we conducted a thorough assessment of the case and reviewed our client's history before determining that a subclass 155 was the most suitable option. The outcome, the case officer was satisfied. Our client demonstrated substantial ties were a benefit to Australia and that a compelling reason for her absence was present in the case. Our client's subclass 155 was approved. We at Aust Migration are dedicated to help you right from the beginning you start your life in Australia. We have been in the industry for over 20 years and handle several countless complicated cases. If you are unsure and need assistance with any of your visas, please call us on 96548611 or email us at info@austmss.com.au. Once again, please like, subscribe and turn on the notification bell to remain updated on new migration videos.